You may have heard, and if you've listened to me at any time, or if you've read any of my blog posts on my website, employmentrightsireland.com, you will have noticed that 80% of unfair dismissal claims which are lost by employers are lost for one reason, and that one reason is lack of fair procedures and natural justice in the way that they carry out the termination of employment. I recently wrote a blog post about such a case, and it is a typical example of how an employer, even where they feel very strongly that they are in the right and that they're entirely justified in terminating the employment, get caught out and are basically at the tail end of a decision against them for unfair dismissal. Now, they may have been perfectly justified in doing what they did, in other words, in arriving at the decision that they arrived at. However, the procedure is the procedure is the procedure, and you do need to give fair procedures. Let me explain this case. The decision was published in December of 2018. The hearing was held, I think, in July of 2018. It involved a part-time bus driver. The allegation against the part-time bus driver was that he had stolen 20 used wheel rims, I think bus wheel rims, in the workplace. His position was that he had the permission from his supervisor or manager or somebody up the food chain. And what happened was a services manager, I think, carried out an investigation and then arrived at a decision at a disciplinary hearing that the employment was over, your job is terminated, and this is essentially misconduct or gross misconduct or whatever, and you're out of the job. They offered him the opportunity to appeal, and he did appeal the decision. However, the appeal was never heard. Excuse me. And by the time he came on to the WRC hearing, the appeal had never been heard. So that was one problem with in relation to fair procedures and natural justice. But the other problem was one which can be easy enough to fall into, quite frankly, and it is where the investigator essentially makes the decision. So generally there may be two stages in a disciplinary procedure. There's the investigative stage to see whether a person has a case to answer, and it's a fact-finding stage. And then there's a disciplinary stage. In other words, if having carried out an investigation, the company or employer decides that a disciplinary procedure is justified and warranted, then it moves on to the disciplinary stage. However, it is not a good idea from a fair procedure and natural justice perspective to allow the same people or persons be involved in the investigation and be involved in the disciplinary procedure. When this employee received his termination letter, it said, following an investigation and the disciplinary procedure or whatever, your employment has been terminated. However, the disciplinary meeting was carried out by the services manager. The services manager had also investigated the allegation, and the letter came from the employer then to the employee saying, following investigation, the disciplinary sanction is essentially termination or something of that nature. But that is clear evidence that there was investigation carried out. So A, you have an investigation, B, you have a disciplinary situation. So you have a two-stage procedure, and you have the same person, the services manager, involved in both stages. That essentially is unacceptable from the perspective or view of the Labour Court and the WRC, and from the perspective of natural justice and fair procedures. So the bus driver won his claim for unfair dismissal, but not only did he win it, he won reinstatement, and he won restoration of his salary backdated to the day of termination. So I'm not 100% whether it's from the date of termination to the date of the hearing, or from the date of termination to the date of going back to the job, having won this decision in December of 2018. Because obviously there's a 6-month gap between the hearing in July of 18 and December 18 when the decision was handed down. But in any event, it is an expensive lesson for the employer, because the employee has been restored or reinstated to his position, and his salary from the date that he was terminated to was reinstated. I hope you find this video useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you do, remember, we will be connected until one of us passes away. To reiterate though, in relation to fair procedures and natural justice, it is critical, if you're an employer, to afford fair procedures and natural justice to an employee, because even if you feel entirely justified in arriving at the decision that you've arrived at, if you don't do the fair procedures thing, then you're going to lose your case. The employee will win. And the other important point to remember is the WRC adjudicator in this case again confirmed that it is not for the WRC to decide upon the rights or wrongs of the actual allegation against the employee. In other words, the WRC adjudicator, or indeed the Labour Court, are not concerned about the allegation being proved, about the guilt or innocence of the employee. What the WRC were concerned about in this case was, did the employee lose his job after fair procedures and after having been given natural justice and after having been given the chance, fair chance, to address the allegations, to deal with them, to question witnesses if necessary, to test the evidence, and ultimately to appeal. And essentially in this case, as I say, it fell down on the grounds of fair procedure. The employee won his case, and if you find this video useful, please give it a thumbs up down below. And as I say, you may be interested in subscribing to my YouTube channel.